But not quite yet, so I won't say good afternoon. I'll still say good morning and thank you for your patience. I'm going to wait to be sure that we're all set before I call the case with our recording. Okay, I guess we are. All right, so the next case is Elizabeth Werner versus 57 East Pleasant Street, LLC and others, 2024-0475. How are you?
Thank you, Your Honor. May it please the Court. Michael McDonough of Egan Flanagan Cohen, on behalf of Jackson, Elizabeth, and James Werner, who are here with me today. This Court should vacate the judgment for three reasons. First, the defendants owed a common law duty to plaintiff Jackson Werner to provide a safe vehicle return process in Amherst, Massachusetts. Second, the defendants assumed a duty to safely and reasonably instruct the plaintiff, its customer, on the return of the vehicle, and they breached that duty. Third, the case of Davis v. Westwood has been misapplied and actually supports vacating the judgment and allowing a jury trial on the fact issue of the assumption of the duty. Turning to the first point, the defendants owed a common law duty of care to plaintiff Jackson Werner. Every actor, including these defendants, has a duty to exercise reasonable care to avoid physical harm to others. This is especially true, of course, whereas here, the risk of harm to another is recognizable or foreseeable, as it was on October 21st, 2017, on the busy street of Triangle Street in Amherst, Massachusetts, a college town on homecoming week with a crowded intersection.
Can I ask you a question and interrupt you? But in this case, your client did not actually follow the instructions that were given, right? Made the determination that to follow them would be dangerous or would not, could have the risk of his car being rear-ended. How does that affect this in this situation?
Well, he did, and there is a duty to provide those safe and reasonable instructions. The instructions here, he tried to follow them, and his transcript is in the record. But as you'll see in RA 259, Record Appendix 259, the instructions instructed him to leave his vehicle in the threshold of the road, and I don't even want to say sidewalk because there's barely a sidewalk. There's no shoulder. And the vehicle, 259 is a photo of another customer trying to follow these instructions.
With his CRV.
Correct. With the vehicle extended over the white line into the lane of oncoming traffic, requiring those behind to go to the other lane head-on with the other lane of traffic approaching the intersection. So he tried.
Sorry, I just want to follow up about this photo on 259. First of all, is there anything else in the record about the safety of this, about the, goodness, I've lost control of the English language, about the safety of the directions for returning the car if there's no parking pass? Is there other evidence other than this photo of what it actually would mean to follow the directions?
There's the directions themselves
Okay.
at RAI 80, which tell the user that if the remote control, which would simply eliminate the situation completely.
Garage.
And we think that there's a duty to provide that safe means. The whole purpose of the garage is to get out of the busy street.
Well, and to protect the cars and all kinds of other stuff. Is there anything in the record that from which we can understand how wide this garage door is? In other words, is it a one-car door or a two-car door?
I believe there are photographs of that doorway. I don't have the page references committed to memory.
We have some photos that are super dark and pretty much impossible to see, but I will poke through them. Thank you.
And we'll be happy to supplement in a 16L letter with color photographs.
Well, it would have to be in the record below, right? We can't get new stuff, so
But Your Honor drives an important question. This fact assessment of whether these instructions were proper or given in a prudent manner. And causation and negligence are fact questions for the jury.
But the duty, whether or not there's a duty, is a legal issue.
That's what is before this court today.
And that is a legal issue.
Correct, Your Honor.
So whether we agree or don't agree with what the summary judgment record, that is a legal issue appropriate for summary judgment, and this is potentially, and we could address it.
We don't quarrel with that. What we quarrel with on item 1 is that essentially the trial judge, the motion judge here, misapplied what we were alleging the duty was. Nowhere in our complaint do we claim that either defendant had a duty to control traffic in the road. We understand that a landowner does not have the duty to control the traffic of the adjacent roadway. The duty alleged in the complaint and through this case that plaintiff alleges is to provide an access way to the garage from which the customer rented the car in a prudent and reasonable way. And if you're going to provide substitute instructions, failing on the first duty, provide safe instructions. These instructions were illegal. To leave a car hanging out into the roadway like that is not only dangerous, unreasonable, it's illegal. And that is a fact issue later for a jury to assess, but we're not saying that we're talking about the roadway and common law duty in the abstract. It's the defendant's instructions insofar as those instructions place the customer in that roadway. And then when the customer realizes, I'm going to get struck, or if I go and walk around the building per the instructions in RA 80, past the Bertucci's, around the corner, use the card, and then hurry back with the time, the amount of seconds before that garage closes, get back in the car and get back into the garage. Is someone else going to strike the car? Is it going to cause a collision by somebody veering out of the way? Am I going to be struck hurrying back in there? The plaintiff in this case tried that, and he realized that this was dangerous, and he parked instead the first available location that he could find across the street, and then began that game show-like contest of the gauntlet of getting to the back door behind, pressing the button, and in a certain amount of seconds, getting to the vehicle, getting back across busy Triangle Street, and he was struck, causing catastrophic, permanent injuries, including traumatic brain injury.
So your client is still suffering, I trust, as a result of being hit by a drunk driver on Triangle Street. Would this case be different if he had parked where the CRV is in this photograph on 259 and say, been hit because another vehicle smashed into the back of the CRV, which then hit him and knocked him on the ground? Would that case be the same as this case legally or different?
It would be another risk of the unsafe, unreasonable, and illegal instructions is being struck in that position. Another one is being struck by a distracted driver, a drunk driver, a speeding driver. There were many foreseeable risks of causing a patron to have to stop and figure this out in Triangle Street. And that's where the plaintiff was struck. But moving to the second, there's another theory why this case should not have been dismissed on summary judgment. And that, of course, is the assumption of the duty by the plaintiff, by the defendants here. The defendants here took it upon themselves to design, with 57 East Pleasant, the building, and Zipcar, instruct their patrons on how to deal with that situation. They provided instructions, and
wasn't it Zipcar that provided the instructions? What's the duty owed by the garage?
the garage was the premises.
Right.
And designed this narrow entryway and was aware, Your Honor, of over a month's worth, I think 6 different instances of reports by other customers. The remote's missing. This is inconvenient. We can't get into the garage. They were aware, and the emails in the appendix show a back and forth between the two defendants trying to determine who is going to rectify this. And instead, nothing was done. So the judge here notes that there's a negative duty not to interfere and create issues in the roadway. Here, these defendants knew of an ongoing issue with patrons being confused on busy Triangle Street. Zipcar assumed that duty by giving substitute instructions. Neither defendant took better instructions or prudent care to resolve the issue by providing a new remote or a lanyard in the car so it doesn't get removed, or a keypad right at the door, or alternate parking right on the site. There were no efforts by either of these defendants to do that, and the SJC has instructed that when an entity does take on a duty voluntarily, it must be done with due care. So in many cases, there are examples of neighboring bodies of tort law where there's no duty. The best, again, is Davis versus Westwood, where the SJC said no duty to control the traffic. But when you go and put a off-duty officer in the road acting as a crossing guard, you've now voluntarily assumed that duty, and your agent must perform those duties with care. And that is a common holding in the SJC dating back at least to 1983. In Mullins v. Pine Manor, the college case where an entity has no obligation to the criminal acts or wrongful acts of others, of course. But when it holds itself out and provides safety programs, it must do so with due care. In that case, they just left the doors unlocked, and someone was unfortunately sexually assaulted.
Let me ask you this. So here the judge did not address the issue of intervening cause. Didn't need to get there. Can we get there?
It's a primary argument of both of appellees. It's not dispositive today because in Dole versus Foster, the 2021 SJC case, the SJC held there's no requirement that the defendant be the only cause of the harm and that a subsequent cause can come and increase the damages to the plaintiff.
So you're answering the question well as to what the answer should be, but can we address that? Because our review is de novo, right?
Yes.
So would you say that we could if we were so inclined?
You certainly can, Your Honor. However, it doesn't apply in this case because just like in Leahy versus Standard Oil, an intervening negligence of a third person that contributes to the damages does not necessarily break the causal connection, and that the jury can determine who in the chain of tortfeasors was or liable in the fact pattern. And that goes back to it being a fact question of whether or not there was negligence and causation. But to close the loop on assumption of the duty, the same holding applies in Cottom versus CVS in 2002. No duty of the pharmacies to warn on the side effects of the drugs. But when they start putting warnings on those bottles, now you must do so prudently. When you instruct your patron how to get out of Triangle Street in the absence of your known missing product, the remote control, you need to provide safe instructions. It's absolutely at least a fact issue that the instructions given were unsafe. And then the plaintiff shouldn't be faulted for not following those clearly unsafe instructions and trying to find, left to his own devices, an alternative in the busy street that was the entire purpose of having an off-street parking garage in the first place.
Place where your argument takes a leap, and it may be a leap that is justified by the case law, but is what you just said includes a recognition of what happened, which is the plaintiff was provided with instructions and did not follow them. Do you have a case in which the plaintiff's failure to follow the system that was set up by the person who owes the duty of care still results in liability to the person who owes the duty of care?
Not on that exact hypothetical, but I would draw this comparison. If the instructions were to walk over a footbridge that was clearly broken and fell into disrepair and had a giant hole in it, and the plaintiff clearly decided that would be just putting myself at peril to walk into that footbridge, if the plaintiff is instructed likewise to hold their car out in the busy road where there's absolutely no space in the photographic record before the court, the plaintiff, who then tries to mitigate the breaches of care by the defendants by parking across the street or the next visible spot under the time rush to get the car back in, under their billing system of hourly rentals, and under the time it takes to get to the back, press the button, get back to the car, get in the car, and get in before the garage closes, creating that situation for their customers, knowing that customers are complaining about it, undisputed in the record, the customer complaints, and providing this alternative, the faulty footbridge, doesn't absolve the defendants of their duty of acting prudently, whether that's negligent and whether the other causes are the significant causes. That's a fact question. And the key here is, if I may briefly conclude, not only that there was this misapplication of what we were alleging the duty was in the first argument, but under those assumption of the duty cases, Cottam v. CVS, Davis v. Westwood, Mullins v. Pine Manor, they're all perfect examples of why this judgment should be vacated. All those cases, all those plaintiffs had jury trials, every single one of them. So in Davis, they just found that the crossing guard
Your time is up.
did act prudently. Thank you very much.
Thank you very much. Okay, just
Good morning, Your Honors, and may it please the
all
Court.
right, you got your 10 minutes? Okay, just wanted to be sure that you...
Yes.
All right, okay, thank you.
William Besch for Zipcar. With me is Brad McDonald, who has done most of the work in the case. Let me start by addressing all this discussion about the entranceway and what it looks like and so forth, and then I'm going to tell you why it makes no difference and you should ignore it. First of all, to answer a question that Justice Hershfang asked, the photos that were presented to the Superior Court were actually better quality than what shows up in the record appendix. And if you look at addendum page 46 and 47 to our brief, we reproduce those photos in the quality that's as good as that's as good as the Superior Court had. And what those show, and the photo that my brother was using does not really show, is how wide the apron is leading to that garage, which is wider than the sidewalk, and it really, the photo that shows someone not involved in this case pulling up to the vehicle, there was certainly no evidence or any basis for any assertion that this entryway, this way of entering the garage is illegal. First of all, the building, was permitted and approved to be constructed this way. This is how the tenants get into the parking garage, as well as
They have the clicker.
they may or may not. The problem with remotes getting lost is a problem that is obviously not unique to Zipcar, but it's certainly a problem. But there was no basis on which, even for summary judgment purposes, the plaintiff could have argued that there was something illegal or against the rules of the city of Amherst for this way of getting into the garage.
I don't think, to be fair to his argument, I don't think he's arguing that it was illegal for a car to have to drive across this sidewalk to get into the garage. I thought he was arguing that it was dangerous for a car not to be able to get into the garage once it has started crossing the sidewalk, to have to come to rest, across the sidewalk with its rear
Right,
portion.
and whether that, my point is only that whether that was possible, how much of your car would actually stick into the street was not something that was established in any way in the record. But let me tell you why none of that makes any difference whatsoever, and we can just forget about it. Because for summary judgment purposes, we are assuming, we accept, and we accepted below, that it was foreseeable that Jackson might decide that he didn't want to do it that way, and that he would do what he did, which is pull around the corner, come into a parking lot across the street. So we're granting, suppose we put him in that position, where he parked across the street and he had to walk across the street to get into the garage. What then is the question? Did we breach a duty by making him cross the street to get into the garage, or did we assume some duty to make sure he could get safely across the street? And I think that's where all of the cases about customers having to cross busy streets are directly on point and answer the question. If your customers, in the Wonderland dog track case, it was not only foreseeable, it was on purpose that the parking lot was on one side of Route 1A, 4 lanes divided, and the racetrack was on the other side. All the customers had to cross, and the dog track recognized that by posting people to help, officers, off-duty officers, to help them get across the street. And still, the court said, no duty. If you're going to assume a duty in the sense of hiring the officers, you have to do that part. You can't hire children or teenagers to do that job. You have to hire, but beyond that, you're not responsible for your customers crossing an ordinary street on their way to get to your business. You don't have control.
In this case, if I'm not mistaken, there was not just an ordinary crossing of the street. There was some sense of a rush, right? Because once the door is opened to the garage, you have to get back and get your car and get over.
There was certainly no, the accident occurred when he was on his way across. There was no hurry for him to do that. So
I said before he reached the zip car.
Before he reached
not
the
on the
garage.
other side. Okay.
Yeah, I don't think there's any evidence in the record as to if he had completed this strategy of doing it this way, how long the door would have been open, or whether he would have been able to do that, because it never reached that point. He was struck when he was initially crossing the street on his way, and there was no time pressure on him at that point. So again, I think the Davis case, there are several cases, unpublished cases, decisions of this court that have followed Davis and in 2003 and 2004 followed Davis and held in similar circumstances that, even if even if it's foreseeable that your customer is going to be in a busy street, and there was no real evidence that this street was more or less busy or how fast the cars were going, anything like that. Very spare evidence on that point. But even if your customers are going to have to cross a busy street like Route 1A, and even if even if you know that's going to happen, and even if you take some steps to protect them in the street, which we don't have here, you don't owe a duty to, because you don't control the street, the government controls the street, and you don't control the drivers in the street, you don't have the ability to control the drivers in the street. And that's why while the plaintiff, the appellants try to define the question as, did Zipcar have a duty to provide a safe way of returning a car? Well, at that level of generality, it would be hard to argue that the answer is other than yes. Yes, we had a duty to provide a safe way to return a car, but what is the risk that they say we created through our allegedly defective method? The risk was that Jackson was put in a situation where he had to, according to them, park across the street, in this lot across the street, and walk across. So suppose that had been our procedure. Suppose our procedure had been park in the parking lot across the street. If you don't have a remote, park in that parking lot, come over, and get into the garage that way. It's the same analysis. Do we have a duty to prevent a customer from having to cross the street to get to our business? The answer is, as a matter of law, no. Justice Vuono, you asked about the superseding cause issue. You don't have to reach that. You can reach it. Our only real reason for including it is that I think it bolsters the chain of foreseeability that you have to get to all of that, plus then you have the intervention of a drunk driver, I think makes this a case where it stretches the bounds of foreseeability so that it should be, the drunk driver should be deemed a superseding cause, but you don't have to reach that issue, because this is a duty case, and Zipcar had no duty as a matter of law.
Thank you.
No other questions?
Good afternoon. My name is David O'Connor. I represent 56 East, which is the garage.
I thought it was 57 East.
Thank you. Yeah, thank you. I'm thinking of the rule. What I'd like to bring to the panel's attention are the distinctions between my client's legal position and those of Zipcar, particularly because the plaintiff, I think, intentionally, although perhaps disingenuously, groups us together as if my client's renting parking spaces for $150 a month for 3 spaces equals a joint venture, okay? My client and Zipcar have a very limited relationship. We have absolutely no relationship with Jackson or any of the people who use Zipcar services. There's been no allegation that the door was defective. There's been no allegation that the premises were defective. There's been no allegation that the way in which 57 East used its premises created a risk in the road, particularly one associated with this unfortunate accident involving a drunk driver. The argument about, busy homecoming weekend and all these types of things, my client doesn't control that. My client doesn't foresee that. My client allows Zipcar to use 3 spaces. And the evidence is we equipped them with garage door openers. The business model, I think it's in the record 201, perhaps 205, there's an exchange where we and my brother, I think, made a little bit too much of it about all these complaints. We're not aware of those. But the issue was raised, and Zipcar acknowledged that its people don't always read what they tell them to do. And they also acknowledged that their business model sometimes causes these things, which are in the visor, to be lost. Because sometimes they take a vehicle out of service. And they may strip the vehicle, as they indicated in the record in 201 to 205. And then the garage door opener is gone. So my client rented 3 spaces, provided a garage door opener. There's no allegation that there's anything wrong with the premises. It passed. It was given a certificate of occupancy and all the rest. Furthermore, Your Honor, or panels, one of the distinctions here, too, is unlike Davis, I would suggest that my client is in a even more insulated position than the defendant in Davis. The reason for that was, or is, because the defendant in Davis had revenue on both sides of the street. Okay? It ran Wonderland, it ran the parking lot. Okay? It was necessary, it was essential.
Excuse me.
Listen. It was necessary and essential, more than just foreseeable, that people would have to cross Route 1. And even in those circumstances where that defendant, Wonderland, had control of both sides, was transacting revenue on both sides, no duty was established. Another thing I want to get to, if I may, because I'm running out of time, is that in terms of the assumption that we took on some additional duty, we're being confused with Zipcar. We didn't prepare any instructions. We didn't have a way to communicate with Zipcar users. We don't have, for lack of a better term, privity with that whole population. Mm-hmm. All we know is we rented spaces and we gave garage door openers. I'd also suggest in terms of the assumption of duty, the there was no record evidence, other than the young man's view post-incident, that the manner in which Zipcar described the vehicles ought to be returned was unsafe. There's no expert opinion. There's no measurement in the record in terms of the width of the cutout in the street. And all the contentions about this being a very busy street, well, it's awfully small and narrow. So I'd suggest, Your Honor, that our position is far different from that of Zipcar, and we don't happen to believe they bear any legal responsibility either. But we are in a far different position, and our duty to people who we have no relationship with, we can't even communicate with them. Mm-hmm. I think in that instance, when you talk about instructions, not only did we not give them, we had no way of communicating those instructions.
So, seeing your time is up, thank you. You don't have to touch anything.
Okay, great. Thank you.
Okay. Thank you very much. Thank you all very much for your arguments. It's a tragic situation, of course, and we're sorry about that, but we'll look at the legal issues and render a decision. All right, good. So I'm going to take a little bit of time before I call the next case, because we want to be sure that we have the recording system working. So I'm just going to call the case and see how it works. So it's 2024-0088, Wicket-Lite Supply, Inc. versus Woodforest Lighting, Inc. How we doing? Okay. I understand the recording system is working, so you may take the podium.
May I, before we actually start the timer, I just want to ask about the name of the plaintiff. So on our docket, it's Wicket-Lite, like everybody is playing croquet and there's a sticky wicket. But
wicked.
it looks in the briefing like it's Wicket-Lite, like it is a local Boston company that is saying Wicked. That's correct. It's Wicked. All right. Thank you.
I changed that. I fixed that already. I should let you know.
Good afternoon, Justices of the panel. My name is Michael Fencer, and I am here for the two appellants, which Woodforest Lighting and MLS Company Limited, who were defendants in the trial court below. Your Honor, this is an appeal of one component of two judgments. The jury entered verdicts in favor of the plaintiffs against one of the defendants on a certain amount of damages and against both of the defendants on a larger amount of damages on a joint and several basis. And after the trial court reserved the 93A ruling for itself, the trial judge entered a judgment finding a 93A violation, finding that it was knowing and willful in allowing treble damages against the defendants on both of those judgments, as well as an award of attorney's fees. The defendants are challenging here today two findings made by the trial judge that supported the 93A violation and the court's finding that the violation was knowing and willful. Specifically, the trial judge found that Woodforest knowingly sold plaintiffs a product that was defective and that Woodforest knew or should have known that was defective and was ill-suited for its intended purpose.
And you're saying that that's based only on the admission of those two exhibits, Exhibit 10 and 11?
That's correct, Your Honor. Exhibit
And that there was
11
no other evidence that would support that conclusion?
No, from the defendant's standpoint, the only evidence of any putative cause of a lighting defect in the products, these were LED light fixtures, Your Honor, the only evidence in the record of any putative cause was Exhibit 11. And Exhibit 10, which was a transmittal email from defendant Woodforest to the plaintiffs, providing the report and reciting what the three alleged causes were.
Well, there was evidence that the lights didn't work, correct?
I'm sorry, Your
There
Honor?
was evidence that the lights were not working, that they were flickering and strobing and things of that nature.
There was evidence that there was a limited number of lights that were installed by the plaintiff that were flickering and strobing, Your Honor. But there was also the plaintiff, the plaintiff's case was largely put in by the testimony of its plaintiff, Ms. Kelly Coda. Ms. Kelly Coda admitted during her testimony at several points that these kind of strobing and flickering was not an uncommon feature for LEDs. She basically described them as circuit boards. She said that there was any number of things that could cause it, such as vibration, trucking, rough handling. It was a subject of her direct and, of course, her cross-examination. In an email exchange between her and the company about that, she even asked if there was any site-specific causes that could have contributed to it, such as where the light fixtures were installed.
Right?
But
There was no admission on her part that the installation was the reason for this.
She did
To the
not-
contrary, correct?
She did not admit that, Your Honor, no. Once she had received a copy of the report, she staunchly took the position that it was a product-wide defect, and the only evidence that would even suggest that is Exhibit 11, which I
Well, couldn't the jury infer, based on her testimony, that there was a defect in the lighting?
They could, Your Honor, but it's not the jury's verdict that's under review here that the defendants are
Well,
challenging.
okay, so that would be the advisory portion of it. Well, so
But it-
saying, I'll make the same comment. Couldn't the judge then
Yes, Your Honor.
make
but-
that inference?
But the judge could infer that there was a defect, but the real problem here is that the judge said Woodforest knowingly sold a product that was defective, meaning that it would have needed to know that the product was defective when the products were sold between December 2016 and December of 2017. I want to point out, Your Honor, that the product report, the Exhibit 11 in question, has a date in March of 2017.
Right.
Now, the plaintiff purchased about 5,500 of these fixtures. The first 4,000 were in December of 2016, approximately 4 months before this Exhibit 11 would have been issued, if in fact that's the correct date. So it simply is against the evidence, Your Honor, that Woodforest could have known in December of 2016 that it had a product that might have been defective, according to a report issued putatively in March of 2017.
So as I read the judge's decision on the 93A claim, you are correct that the judge talks about Woodforest knowingly selling a defective product. The judge goes on to say, and I'm at 687 of the record appendix, Woodforest's purported remedy for the defective fixtures was to knowingly provide alternative fixtures that would not fit and were not suitable for the use to which they were put. Woodforest's misrepresentations in these regards was unfair and deceptive. I take it you're not arguing that that part of the judge's ruling relies on Exhibits 10 and 11?
I am not, I am not, Your Honor, but
And
before
why isn't that alone adequate to support the judge's 93A ruling?
So on that point, Your Honor, the Woodforest, the testimony and the documentary evidence was that Woodforest had an obligation to provide replacement product under its warranty, and the testimony and the documentary evidence is that Woodforest did in fact provide replacement product. Now,
That was the wrong size
Were
and
not
had the
suitable.
wrong connectors and didn't actually attach in the fixtures as installed, right?
yes, Your Honor, but Woodforest did advise the plaintiff about what products it was going to be sending. There's testimony at Record Appendix 299 to 302. They were in an email exchange that Ms. Coda testified about. Woodforest was telling them that there were limitations on the product that they were selling. They were reacting to the exigencies of the plaintiff. She was looking to get replacement put in there quickly to satisfy her own customers. Woodforest wrote and said, we have these products, and the plaintiff wrote back and says, we're being clear here that these are not necessarily the same products that we had purchased first, and they said, yes, that's correct.
But the evidence still was that was an understanding that they would be suitable.
That they would be
That they
futile?
would still be suitable. They may be different, but they would still be suitable.
That's correct, Your Honor. They did say that they were giving her products so she could try to fix her problems, and they did not necessarily, there's no evidence that they necessarily knew that there's an issue with some of the fixtures were supposed to be a universal voltage, and when they opened the packages up that said
Were not.
universal voltages on them, they found 115, 120 volt fixtures inside. Now, recall, Your Honor, that Woodforest is the one making this representation. It is the seller of the fixtures. My other client, MLS, is the manufacturer of the fixtures. So the problem or the error that occurred here, and the world is not a perfect place, occurred at the manufacturing stage. Now, Woodforest is handling taking these fixtures from MLS that are improperly packaged, passing them on to their client in accordance with their warranty obligations, and trying to help them fix their problem. There's no evidence, though, that MLS took, either MLS or Woodforest, took and repackaged 120-volt fixtures and put them in universal voltage boxes and
So you're saying it was an honest mistake?
It was an honest mistake, Your
Then
Honor.
what steps did either of your client take to fix that honest mistake?
So they continued, the testimony of Ms. Coda is that they had numerous communications. There are a number of electronic mail communications. Not all of them made them into the record appendix, Your Honor. But they continued to work with the plaintiff until she finally had lost her patience and decided to stop working with our client entirely.
And how long was that?
I believe it went into June of 2018.
From when?
From December of 2016. So at one point, the plaintiffs decided that they were no longer going to continue to take product from Woodforest or MLS to try to fix their problem. They unilaterally decided to remove and replace all of the product that they purchased from our clients, and they replaced it with other product. And at that point began compiling damages, and this lawsuit ensued. Mm-hmm. However, during the time frame that the parties were communicating, Your Honors, Woodforest and with the input of MLS was trying to provide solutions. They worked in good faith. There's no indication in the record that they just ghosted them when they started to complain. The first complaint came in.
Is that a thing in business, just to ghost somebody?
Pardon me, Your Honor?
Is that a thing in business?
Well, it's probably, I'm being too cavalier with the term, but they didn't just ignore them is probably a better way to put it. They continued to communicate, they continued to provide product. It's unfortunate that the product didn't work for them, but they didn't just walk away.
Even so, let's take the jury could, of course, and the judge could have found that there was some cooperation. At the same time, there is a limit to cooperation. The judge and the jury could have also found that at a certain point, your client was not fulfilling its obligations because what it was sending was not working. And of course, the person who's receiving them has clients and a business, and can't tell clients, a judge or a jury could reasonably find, hold on till the manufacturer gets back to me the third or fourth time around, right?
That's correct, Your Honor, and that's why we're not here disputing the jury's verdict that there was a breach of a warranty or a breach of a contract. What we're saying here today is that how they dealt with the contract was not unscrupulous. How they dealt with the warranty claims was not unfair and deceptive. How their efforts to help the plaintiff remedy these problems, even if it was found to be involving misrepresentations, doesn't rise to the level of a 93A violation. That's all.
Yeah.
So with that, Your Honor, I'd like to turn to the willful and the knowing and willful finding, Your Honor. We have briefed in the in our appellate brief from pages 24 to 27 a comparison to the VMARK case. That was a case involving some software sales. The software launch didn't go according to plan. The defendant raised issues with it, and the software provider, VMark, attempted to remedy these software defects. There were findings in the proceedings that there were misrepresentations about how the patches and the fixes would improve the situation, and there were findings that they may have been knowing misrepresentations.
One thing that I think distinguishes VMark from the situation here, and I say this relying on the findings by the trial judge, not my own view of the situation. In the VMark decision, the court specifically said VMark's earnest efforts to make good on its contractual obligation by overcoming its product's recognized problems and making it perform to expectations, et cetera. They're actually talking about the tort claim at that point. But you're in a situation, unfortunately, where the trial judge has actually found the opposite, has found that there was not a good faith effort to make good. So how does your client overcome that?
But, Your Honor, as I discussed here, the communications between the parties during this effort to resolve the product, this is the same kind of efforts as occurred in VMark. They did send product. They sent substantial product. There's trial exhibits showing numerous shipments of replacement product at no cost, which is consistent with the warranty. They had at all times contact with the sales representative at Woodforest. They were reacting. They were helping. They even went so far as to send this report marked as Exhibit 11 and to say, listen, now that someone has told us that we have this problem and the report has never been authenticated, and that needs to be...
Well, but it wasn't admitted for the truth of the matter, so I'm not sure that's so relevant.
But I think that the document to be admitted into evidence for any person, any purpose requires authentication, and the document was never authenticated. So, Your Honor,
And what do you say, just because your time is almost up, to the fact that there was argument with respect to the closing argument, your closing argument, that asking the jury to actually look at that document and to read the document?
I raised that issue several times,
Yeah.
Your Honor. It was, every time that document got mentioned, I objected to it. And it was again, all of the same objections with legal development was presented at the 93A phase of the case, Your Honor. So the issue's been preserved all along.
Okay.
I did argue to the jury, as pointed out, that they should disregard the report because although the trial judge did properly instruct the jury that it was only for a limited purpose over my objection, you can never tell what a jury's going to understand about those instructions. So I did have to hedge my bet, admittedly.
Yeah.
Your Honor,
That would have been after you already filed. Your point is that was after you had already objected to the document.
Exactly. Yeah.
Your time is up.
Yeah. We just would like the trial court to reverse the 93A relief. I'm sorry, this court to reverse the trial court's 93A relief. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honor. May it please the court, my name is Douglas Hartman, and I'm here for Wicket-Lite and Wicket-Lite Supply. Two of the rulings that the appellant wishes this court to overturn are evidentiary rulings, and the plaintiff appellee submits that there is no clear error in what the court ruled. The two exhibits that he complains about are Exhibits 10 and 11. One's a cover email, one's the actual report. In fact, the cover email goes further to identify that what they can tell the clients is that they've sourced a new product from a new manufacturer who has better products. I would also like to point out to the court that some of what Mr. Fencer argues in his brief is that this report was not conclusive. The conclusions in the report do state that it was three components of the report, and that further testing needed to be done to determine which of those three, or all three, or two of the three, or whatever it may be, are causing the failures. There's nothing in that report about installations, about dimming switches, or anything like that. So going back to the decisions of the court, there's nothing about, no whimsy about it. It's not arbitrary. It was only entered into evidence for a limited purpose. And I'd also like to point out to the court that the exhibit prior to that, I believe it's Exhibit 9, is an email from Mr. Dorr to Kelly Coda of Wicket-Watts that states the COO, Jan Nye, or Jan.
We don't have that in our appellate record. So there are a number of exhibits that you refer to in your brief that are not actually in the record before us, and I think your citations are to discussions of them in the trial transcript. So we can
Right.
obviously read those discussions, but unfortunately, we can't see those exhibits.
Correct, Your Honor. But my citations to them are in the record. It was her inquiring, have you had any other problems? The response from Mr. Dorr was, there's this report kicking around, and then in September 18th of 2018, you get the email with the report. Now, the email says, here's the report, but it also goes on to say, what we can tell the clients is, what we can tell your clients is that we've sourced from a more reputable or a company with better products and better components. So I think that's, in and of itself, an admission by Mr. Dorr, who is a salesperson of Forest Lighting, who Ms. Coda had been dealing with quite often on these issues of problems with the lights.
Can you, it would be helpful to me to hear your defense or your reasoning in support of the treble damages in this case.
I think the treble damages are supported in this case, Your Honor, based upon the pattern of the defendant. First of all, it provided lights under sale to the plaintiff from December of 2016 to December of 2017. I probably could have stated it better in my brief, but there also was testimony from Ms. Coda in the record that in July of 2018, she was receiving replacement fixtures that were the original fixture, not this other replacement fixtures, the original 5-foot fixture. So not only did they provide fixtures that were incompatible, and I'll get into that in a quick second, they provided the original fixtures that at that point in time, that's well past March 17th of 2017. They know they're having issues
But it's not
flickering.
true, I'm going to try that the other way around. Not all of the original fixtures were defective, correct?
Correct. So the original fixtures, there are 3 different types of fixtures, or 3 different sizes of fixture in this thing. There's a 5-foot, there's a 3-foot, and there's a 2-foot. And they're made to be either run singly or in series. You can plug them together to make a super long fixture. Now, the problem comes in, this is flowing into the next problem of the replacement fixtures that were non-compatible. They would not fit in with the 3-foot and 2-foot fixtures. So when you have a long run, and you'll see in the testimony, these were installed in hallways in labs at Woods Hole and Tufts Dental School. So when you have flickering lights, it's a life safety issue at a place with a lot of people going in and out of it. But that aside, once you cannot replace those 5-foot fixtures, now you have to replace everything because you don't have the 5-foot fixtures. Granted, only the 5-foot fixtures were failing, at least at this time. And there's an admission by Mr. Dorr at Record Appendix, page 300, when an employee, and I forget his name, Mike, and I cannot remember his last name, inquires of Mr. Dorr, is it true that these fixtures don't fit in with the older fixtures? And he says, yes, that is true.
Mike Federici. So,
Federici, yes.
but I guess what I was trying to get at with my question about the original fixtures, and I don't remember whether there's evidence in the record about the percentage of the original fixtures that were failures, whether it was 2% or 10% or 20%. I think that's probably relevant to the question I'm about to ask. But, knowing that there's a problem with a fixture and sending a replacement is maybe not bad faith if 2% of the originals fail You got a 98% chance that the thing you're sending is actually going to work just fine, right?
Well, the problem with the failures is they were becoming more over time. So when we first made the complaint, maybe, yes, it was 2%. I don't know what the exact percentages are. But more and more started failing to the point where in trying to deal with forest lighting and the defendants and in getting replacement fixtures, it got to the point where so many were failing, we did not have, or the plaintiff did not have any 5-foot replacement fixtures, so everything needed to be replaced. There was never anything offered beyond that second replacement, which was the incompatible. They did say they would offer under warranty fixtures from a company called Ledvance. That was never offered to the plaintiff.
I mean, it was offered verbally, but then never tendered.
Correct. And in fact, my client's testimony, she bought a similar fixture from a competitor that worked in this installation to be able to do it. She had to get all the 5, 3s, and 2s to do it. She wouldn't fit in with the original forest fixtures, but at least there was enough to fit out what she had to replace. And then there's testimony at Record Appendix 306 and 307 when Ms. Cota testified she called Mr. Dorr and said, so you sold us defective fixtures, or specifically said, sold us a product knowing it was bad, and that's at 306, 307. She says his response was, well, I don't know what to say to you.
How is that an admission?
It's not a denial that they didn't. That's the most I can say about it, Your Honor. In addition, there was no testimony from anybody that any additional testing was done on these fixtures, that any testing was done that showed what 3 components had failed. Any testing was shown that the test report that was let in for limited purpose was incorrect and had come to a different conclusion. There was no testimony from any party from either Forest or MLS. The only testimony we have concerning their interaction is the testimony of Kelly Cota, and that's it, other than when Ledvance was involved. And I'd also like to point out that the H1 Lincoln case that I cited to is cited to throughout the record. We talked about it a long time, whether the magical words of commercial extortion were said or not, I would submit is not relevant. The course of dealing with the defendants in this trying to replace these fixtures tracks the same thing that happened in H1. And I would also like to say, and the court already pointed out, that the VMARC case is not controlling here and is not helpful to the defendants. That we don't have here where they were trying to help. They already knew these fixtures, replacement fixtures, did not fit. They never came up with anything else. There was the Ledvance promise, which never came through. So eventually, or essentially, the plaintiff was stuck with, we don't have anything that can replace this, and you're going to have to go somewhere else, which is what she did. Not that they said they have to go somewhere else, but by their actions, the only course of action was to go somewhere else to be able to fix these issues. Because granted, the plaintiff, you'll see in her testimony that these places were complaining about the flickering lights. This resolution period with the defendants had taken quite some time. While lights are flickering, more lights are failing, demands to have them removed and replaced were being made. I guess I'd point out that H1 was argued in the motions and eliminated at Record Appendix 49 and 50, and also argued again in the JNOV in findings of rulings at Record Appendix 652 through 653, if I read my handwriting correctly. So in short, the plaintiff, appellee, would ask this court to, if there are no further questions, to uphold and affirm the trial court's decisions with respect to Exhibits 10 and 11 and with respect to the findings of violation of 93A and multiple damages.
Okay. No further questions. I see no further questions from the panel, so thank you very much, both, for your arguments.
Very much.
And that's our last case for today, so thank you, everyone, for the court personnel, and the court stands in recess.